Hello, and welcome to the first webinar in the Ascend series that will be talking about intellectual property today. This is an Intellectual Property 101 course. It's meant as an introduction to many of the themes, concepts, and vocabulary used to describe intellectual property, especially in the academic setting. Thank you for joining us. My name is Jeremy Tamsen. I am the Director of the Office of Technology Transfer at the University of Idaho. We're located in North Idaho in Moscow, and we have a research campus here that houses around 12,000 students total. We do have some specialty area in biomedical research, and we are an Embry institution, as well as a Cobry institution. So, we're here to talk about intellectual property. And what do we mean when we talk about intellectual property? At the very basis, we're talking about intangible property established and recognized by law. We're talking about something that allows right holders exclusive rights to use the intellectual property. And so when we talk about exclusive rights, it's the power of intellectual property is the monopolization of the use of some particular idea or concept. And it allows you as the right holder to exclude others from practicing that same idea. But at the very basis, we're talking about a legal system for legal rights that allows you to enforce your rights against others by obtaining remedies against those who practice your invention without the right to do so. So in the context of college and university activities, we're largely talking about a risk management practice. And in this sense, intellectual property is a shared responsibility for all of those at an institution. And that's why it's important for every researcher to have a basic understanding of the concepts that we'll discuss today. So why is it so important? The university, of course, has the research and education missions that are core to our nonprofit values. We share a need to innovate, and we share a need to educate to allow our faculty researchers to teach and to research. But intellectual property, importantly, protects and preserves those rights while also allowing third parties to operate using the inventions and ideas that we discover and create here. So in this way, intellectual property is core to all of the key missions that the university is supposed to fulfill. So again, referring back to the definition, we're talking about a group of property rights. At their very basic level, these can be bought, sold, and traded upon. They're a property right much like you have in maybe a car or an automobile. Again, intangible property established by law. So it's not a car, it's not an automobile, but you have similar rights in it as if it were physical property. And you can license it to others, license those rights to others. In other words, allow others to use the rights that you rightly deserve and that you have rightly protected. So we're going to talk about this broad category of property rights in somewhat of a continuum. And now this is an imperfect continuum description, but we'll get into trade secrets, copyrights, trademarks, contracts, and patent rights, moving roughly in order from easiest to obtain to most difficult to obtain. So the World Intellectual Property Organization, defines intellectual property as creations of the mind, such as inventions, literary and artistic works, design, symbols, names. And what's important about this definition is that when used in commerce, the commercial property right here is what we're talking about today. And intellectual property is protected in law and allows people to leverage what they've done to gain recognition and financial benefit. And I especially like the last sentence here. The IP system aims to foster an environment in which creativity and innovation can flourish. Again, intellectual property sits at the tripartite mission of allowing us to research and educate and allowing other third parties to utilize those outputs. So the first definition that we'll touch on, the first term that we'll touch on, is trade secrets. And now trade secrets I put at the beginning of the difficulty to obtain continuum because trade secrets, you don't have to file protection on them to obtain them. Now, you have only yourself, though, when you come to maintain the trade secret. And so that's why it's a bit imbalanced. They're easy to obtain, but they're difficult to maintain in the long term. However, they can be extremely lucrative. A trade secret is defined as follows. A trade secret is information that has value by virtue of not being generally known. The information has value to others who cannot legitimately obtain the information. And the information is subject to reasonable efforts to maintain its secrecy. So this is the definition that comes from the United States Patent and Trademark Office, or the USPTO as I'll refer to it. This definition is important because it underpins the federal understanding of what a trade secret is. Before the federal definition of trade secrets, there were a bevy of state laws that rendered definitions in somewhat different language and in somewhat different terms, and allowed rights holders in trade secrets somewhat uneven remedies across the nation. And to remedy that problem, in 2016, the federal Congress passed the Defend Trade Secrets Act into law. And when that act was signed into law, it allowed a federal remedy that was evenly applied across the entire United States, enabling trade secrets to actually increase in value and have a more appreciable leverageability in commercial settings. But trade secrets are a little slippery. You are the only person in charge of trade secrets. If you have one, you have to put it in a safe. You have to put Superman by that safe. You have nobody but yourself to blame if you lose your trade secret. There are lots of examples, though, about how trade secrets can be held very closely and how they can be commercially leveraged for a very long time. Coca-Cola recipe is a very primary example of this. The Coca-Cola company has done several other innovations that have allowed them to capitalize on this recipe, but the foundational flavor of the Coca-Cola Classic is a trade secret recipe that has never been registered as a patent, never been otherwise protected. So you better bet that they have Superman and a safe and a whole bunch of dogs and a whole bunch of other measures in place to keep that recipe very controlled. And now when you have somebody who infringes on your trade secret, in other words, goes and practices your recipe without your authorization, who do you call? Do you call the trade secret police? You don't. There are no trade secret police. It's again just you. You're responsible for maintaining it. So these could be really a lot of different things, but key is that it's information. It could be a formula, a pattern, a compilation, a program, a device, a method, a technique, or a process that derives independent economic value, actual or potential, from not being generally known. So what I'm reading here is the Idaho specific definition, which again, these vary from state to state. And in May of 2016, we have that federal definition now. So another term of art for trade secrets is the misappropriation, or the acquisition of a trade secret by another person through improper means, and then disclosure of that trade secret without the express or implied consent. So this is basically taking the trade secret information and giving it to somebody else when you shouldn't be doing that, right? We call that, in this setting, misappropriation. So the next form of intellectual property that I'll cover is copyrights. And now copyrights may be more familiar to more people because more people are able to interact with copyrights and protect their copyrights in different settings. And that may not always be very commercially important, but often it's extremely important to reputation and to other things. So the U.S. Copyright Act protects original works of authorship fixed in any tangible medium of expression, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. So this definition is very well tested. You can see that they have built in lots of language to make it durable, so that when new technologies come up that copyright could be applicable to, you're still able to utilize copyright to protect your rights. So copyrights are used to protect authors' rights in software and websites, underlying code, video, pictures, music, literary works, architectural works, sculptures, and more. And really critically, they're used for software, as you can see. These are some key points about copyright. These protect, like I said, the expression of original work of authorship and elements of that expression. What it does not protect is the underlying concepts expressed in that language or in that exact expression. So it's not like protecting your idea using a patent, which we'll talk about later. You're only protecting the exact expression, the exact features of that expression. And copyrights, I say more people can interact with them because copyrights do not require registration for you to be able to claim them in your original work. Rights affix at the time of expression once you fix it in a tangible medium. So that could be typing it into the computer, that could be recording it into a recording device, making a video, taking a picture, it could be drawing it on a page. Any of those things count as fixing it in a tangible medium that can later be used to reproduce it, or the other things that I listed in that definition. So rights affix at the time that you create the original work. However, you are provided with enhanced remedies against infringers if you federally register your copyright. There are state copyright registration offices, but most copyright holders want federal protection if they register their work. When you do file a copyright claim, you write up everything that you are claiming is yours. You fix it in a tangible medium, and you send it to the Copyright Office. And they essentially put a timestamp on it and say, yes, we recognize that you have filed this and you are claiming this as your original work. From there, if you have an infringer, that's your first piece of evidence. You take that piece of evidence to the court and you say, look, I told them this was mine on this date, and later these people made something that was so similar that it's indistinguishable. And that is the basis for the start of your claim. So that, again, having that registration helps because it gives a very potent piece of evidence at the start of your issue. And you put others on notice that you're claiming rights in your work by designating that you're claiming the rights, using the circle C, and usually by dating it so that you're indicating this was the date on which I fixed this expression in a tangible medium. So other terms of art for copyright include author. So this is, of course, the creator of the original expression in a work. And the work of authorship, or more generally, the work. This also could be referred to as the creative work, or the original work. So an original expression fixed in a tangible medium. Okay, these definitions become repetitive, but the examples are helpful. And you can see those there: literary, musical, dramatic, pantomime, choreographic, pictorial, graphic, and sculptural, motion pictures and audiovisual works, sound recordings, and architectural works. So again, these are intellectual property rights, allowing the rights holder to exclude others from practicing the right. In this instance, it's from using this creative expression. So the copyright owner can reproduce, prepare derivative works, distribute. They can have exhibited publicly. They can perform through digital and audio transmission publicly as well. So all of these rights are rooted in the copyright claim that is rooted in the original authorship expression. So there is a doctrine of fair use in copyright. There are several factors that apply to the fair use doctrine. The fair use of a copyrighted work for purposes such as criticism, comment, news, reporting, teaching, Scholarship or research is not an infringement of copyright. In determining whether the use is made of a work in any particular case is fair use, the factors to be considered shall include the following: the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect of the use on the potential market value for the original work. Again, we'll talk about copyrights in terms of the circle C. That will be your notice. They can be used to protect a variety of work, and key today is that this is also applied to computer code. Now moving on to trademarks, a wholly different side of the law, or of intellectual property law. And this is an area that many people have experience in because these are very visible expressions of intellectual property. Now, we have a range of logos here. I have an old Apple logo, which shows a graphic trademark. This mark has no words associated with it. And so when this application is filed, you must describe that graphic apple in very descriptive language. And so you'll have to break down every single color. And if you want to define those colors with specificity, include the color codes for them and all of that information to make sure that that it's described accurately. Then you also submit a demonstration of it being used in commerce. So you would show that you were actually using this Apple logo. The Google logo there is shown to demonstrate that you can register simply a word mark. So Google has registered, or Alphabet, excuse me, is the owner of Google as a trademark. And when you look at that trademark filing, it's just the word Google typed out, none of this color. But the word mark is protected in their use categories, which are substantial. And now that they have the rights in that word, they're allowed to customize the appearance of that word and still retain their trademark rights in that expression of the word Google. So you see this every single day on their website. They change it, but they're still protected in using that logo, just like they are here, where it's shown with a variety of colors. I've also included one of our institutional trademarks for the University of Idaho Vandals. This mark is a good demonstration that a trademark can be registered that is a mix of symbols, colors, and words. And so this entire logo mark is a registered trademark. And you can tell because we have a little circle R by it there. So what I mean by that is rights affixed in a trademark at the time that you begin to use it to identify yourself as the source of a certain product or service. Similar to a copyright, the rights affixed at the time that you do the thing. But if you use the TN symbol at that time, you're also putting others on notice that this is your trademark. Now, we saw a circle R on the other one. You only get to use the circle R once you've fully registered the trademark. And when you do that, you also have enhanced protections and remedies in the event of a dispute or in the event of an infringing party using your mark on services and goods that are not coming from you. We have trademark applications in two categories: use in commerce and intent to use in commerce. And so when I mentioned you have to submit a demonstration of you using the logo, that's a requirement of the trademark filing when you ultimately get your protected mark. That's a required step before you get the circle R. So in other words, you have to file and show that you're currently using it or that you intend to use it within a short amount of time. The U.S. Patent and Trademark Office wants to make sure that trademark names are not being taken up and not being utilized in commerce. For this reason, they have a requirement that you demonstrate your use of the mark in commerce to identify yourself as the source of a good or service before you're enabled full protection in that mark. Again, I'll drive home the point that when you have not yet registered your mark, you use TN. That tells other people that you're claiming that as your trademark. Once you've registered the mark with the U.S. Patent and Trademark Office, you use circle R to indicate that you are the full rights, you're reserving full rights in that mark and the rights are reserved to a specific rights holder already. Now, I say the U.S. Patent and Trademark Office because, again, most people who are protecting a trademark want to protect it across the entire United States. There are some state trademark offices. However, most of today's registrations go through the USPTO. So we'll move down now to contracts. And while contracts may not be traditionally thought of as an intellectual property right, they most certainly are. And this is an interesting side note before I get into the specifics on contracting, is that this is an example that I'm sure you've seen something very similar and often much, much longer than this, that you have no choice. You can either, I accept the terms and I continue and I'm able to open the program or the service that I want to access on my electronic device, or you click no and it closes or it turns off. So it's not much of a choice, but this is a legally binding agreement. This comes from a legal fiction that was written into a court decision and upheld again and again that when you open the software package, it's essentially when you purchase the software in a box and you opened the package, that was you constructively accepting the license agreement that was inside. You would open the box, you would read the agreement, and if you didn't agree to the agreement, you didn't put the loading disk into your computer to start the program. You would close the box and send it back to the manufacturer and ask for a refund. Well, today we don't have a box and there is no pamphlet. So instead, we have what's called a click wrap agreement. You open the click wrap by accepting the terms and conditions and clicking next to open the program. Constructively, the courts say that's you opening the package and initiating the product or service. So contracts, again, they are a form of intellectual property rights. They set the rights and obligations of parties relative to one another. They can set restrictions on how assets are used, including intellectual property, by third parties. Usually they require the advice, understanding, and negotiation of maybe an attorney to complete. And that's why they're closer to the end of the difficulty to obtain continuum that I discussed at the beginning. Now, they also provide enhanced evidence and enhanced protections in the event of a dispute. And there are a lot of ways that contracts are written to ensure that certain federal laws and certain state laws apply to the contracts. So if you see a contract that seems overly wordy or overly lengthy, it's sometimes for the reason that they're using special words to trigger special remedies in court. So this is where we are in the continuum of difficulty to obtain. And now we're feeling pretty good. We've seen trade secrets, we've seen copyrights, we've seen trademarks, and we've talked some about contracts. Now I'm going to delve into patent rights. And I'm taking a pause here because this next section is a little bit denser than the section that we just finished. So patent rights are a form of intellectual property that are used to protect novel, useful, and non-obvious creations. So this is, again, a right to exclude others from making, using, offering for sale, or selling an invention throughout the United States or a territory that is registered with the WIPO. We'll talk through that later. These patents provide protection in the event of a dispute. So what we're talking about here is a monopoly. You come up with an idea, and the United States will give you a monopoly if you apply for and have registered a patent. This monopoly is a right to exclude others, and it's a time-limited reward for public disclosure of the invention. What does that mean? The monopoly is a reward. We get that. It's time-limited. Why? Because you just told the world how to make your invention. You wrote every detail down in a patent application that, when issued, becomes public. That information could be used by any infringing party thereafter, and therefore the protection that you get from a patent is important, but it's key to remember that when you file for a patent and it issues, you are doing what's called an enabling disclosure. This is required by law. It's required in patent law that the application is a fully enabling disclosure so that the patent office can understand your invention and so that others who are skilled in the art can understand your invention as well. And in return for making this invention public altruistically and raising all votes with your new invention, you get a time-limited monopoly to capitalize on the value. So again, this is a property right. It can be bought, sold, and traded. And the owners must enforce their own rights. There's no patent police to call. I call my attorney if I find an infringing party, and they take that infringing party to court. Now, the court can act more quickly if you've registered your patent with the United States. What that means is you're allowed injunctive relief in the case where you have an issued patent. You can tell the court, hi, I have an infringing party, and before we go through the entire process of finding all the information and gathering all of the pieces, court, I need you to tell them to stop manufacturing this device or stop having it shipped into the United States. It could be a device or any other patented product. So the court can act more quickly by stopping that party by issuing an injunction before having to go through an entire legal battle. And this can offer parties protective relief sooner in the case that they do find an infringing party that's seriously curtailing the commercial value that they're netting from their time-limited monopoly. So the first line of dispute on any issued patent application or issued registered patent is the PTAB. And the PTAB is the Patent Trial and Appeal Board, which is part of the United States Patent and Trademark Office. It is not part of the US court system. The decisions of the PTAB are appealed then to the US court system. The important thing to remember is inventors are forever recognized in the patent application, and so is their work. The rights that the patent application gives to that inventor can be bought, sold, and traded, so there may be a long story of who owns the patent after the inventor invents it, but the inventor is always the inventor and will always be recognized as such. A few terms to know for patents. An invention, this is a really helpful, I think, definition from the US code, is invention or discovery. So an inventor is the individual, or if a joint invention, the individuals collectively who invented or discovered the subject matter of the invention. A joint inventor or co-inventor are any of the people who invented or discovered the subject matter of a joint invention. So this next definition is especially important when we're talking about research and development work in the academic setting that was conducted using federal research dollars. Those federal research dollars are subject to the provisions of the 1985 Dole Act. And the Bayh-Dole Act said that subject inventions can be claimed, ownership of subject inventions can be claimed by the institutional operators of a federal research grant, but we have to certify and report back to the government in certain ways on that invention. And those inventions that are subject to this rule are called subject inventions. So a subject invention is any invention of the contractor, i.e. the university and its constituents, conceived or first actually reduced to practice in the performance of work under a funding agreement, provided that in the case of a variety of plant, the date of determination must also occur during the period of contract performance. We'll talk about plans in a little bit later, but the important thing to remember here is that federally funded work and work that's funded through state flow-through agencies are called subject inventions, and that the government retains certain rights in those inventions. So continuing into the terms of art from covering patenting, conception is the formation in the mind of the inventor of a definite and permanent idea of the complete and operative invention as it is thereafter to be applied in practice. So this is the inventive moment, or the inventive series of moments that take something from a mere whiff of an idea to a fully fleshed out idea of what it will do, a fully fleshed concept of how it will actually work, and how that work will actually be applied in some setting. Actual reduction to practice is defined as the reduction of an idea to a tangible thing that actually works for its intended purpose. Now, reduction to practice does not have to be full scale. You do not have to know every step that it's going to take to get it from the bench to the actual market, but all of those steps in between are reduction to practice steps of some kind. But the very minimum, you have to demonstrate actual reduction to practice to qualify for patent protection. Constructive reduction to practice is, now when the courts and when the law uses the word constructive, they're really saying fake. And so we're talking about fake reduction to practice here instead of actual reduction to practice. Constructive or fake reduction to practice is the description of the invention by means of a patent application that satisfies the US law. i.e., it has to disclose the invention in a way that satisfies the how to use and how to make requirements of the patent code. So this allows for provisional patent applications to be validly obtained and validly issued by the Patent Office. Prior to constructive reduction to practice, provisional patent applications would not have had a home from the US, or would not have gotten blessing from the USPTO because they were not actually reduced to practice. Now, the provisional patent application allows inventors to describe the conceived invention and get fake reduction to practice long enough for them to actually reduce it to practice for the full patent registration. This is obviously a time-limited allowance, but it is an allowance that gives inventors a little bit more protection when they're reducing their invention to practice. We talked about an enabling disclosure and what that means when you make it to the Patent Office. Well, an enabling disclosure can also be made to any other third party. So an enabling disclosure, the requirement of the patent code is that you do fully describe your invention and how it works and how it's intended to be applied. And now if you do that same describing to another third party, you could have made an enabling disclosure that prevents you from getting patent protection in the future. This is an important thing to note, especially in the academic setting. If you intend to patent your work, be sure to work with your technology transfer officer or similar representative at your university or institution before you publish on that work. If you publish first, you may lose out on certain future rights. And you can become what's called prior art for your own patent application if you publish too early. Prior art is all information that is publicly available before someone claims to invent something. Patents are only allowed for things that are novel and non-obvious. Novel meaning new. If the prior art contained in the description for the supposed invention, it cannot be novel. So what that means is that the Patent Office will look at every publication, will look at every newspaper in attempts to find prior art that describes your invention, either in whole or in part, and if only in part, they'll look for other references that combined describe your invention. Sometimes they jump through hoops doing this, and they create a very difficult case against your patent application. So don't be dismayed. The examiner is just doing their job. They want to make sure that if they do register a patent to you for your concept or for your idea, that it actually is novel and non-obvious, so that you're assured in your rights going forward in defending your rights against others. So we'll talk about several different types of patents. Today, we'll touch on plant patents, we'll touch on human biology patents, we'll also touch on design patents, and we'll touch on utility patents. So the two pictures that show drawings here are actually part of patent applications. So the toilet paper roll. I use this example to illustrate a number of different things about patent applications. Number one, figures are required. A figure that demonstrates how your invention will actually be used in practice is necessary for the application. So this is a utility patent application. A utility patent application protects the actual usefulness of your invention. Here we see a perforated roll, and here it's described as a toilet paper roll, but the same patent was also used to describe gift paper on rolls. So you might see that at a department store where a tenant was wrapping gifts for people. One patent, multiple uses. Today that's a little more unusual. You would normally see what's called a divisional patent, or you would just see an entirely new patent application for the new subject matter. The next we have design patents, and this is the very recognizable Coca-Cola bottle, the original one. And now this has become somewhat of an American icon, and the radius of the curves and the overall shape of the streaking, the indentation on the area where the label is affixed, all of these features were described very carefully in a design patent application. Features that were not described in that design application include the way that the lip meets the lid, for the reason that this application was not intended to protect that function of this bottle. The only thing this application was intended to protect was the ornamental design of the bottle itself. And patents can be obtained also for plants when they are asexually reproduced. And we have these descriptions here. And the methods for asexually reproducing plants include budding, fragmentation, fission, spore formation, and vegetative propagation. Vegetative propagation, what do I mean by that? Well, a seed potato is a great example, and I'm using that example not coincidentally that we're in Idaho. The seed potato is an example of a vegetatively propagated plant in that you dig up the potato, which is the root of the potato plant, you divide it, and you plant another piece of it. That's technically the vegetation from the plant being planted back into the ground. Now, this is an asexual reproduction. It's a clone of the same plant that you just dug up. And that's important because only asexual reproduced plants are allowed plant patents. And now, again, we see that design patents are may be granted to anyone who invents a new original ornamental design for any article of manufacture. Again, we're talking about use in commerce, we're talking about the property right, we're talking about excluding others. So really, it needs to be manufactured. It needs to be have been made more than once for your patent to really give you any leverage for a design patent. So utility patents, to back all the way up, may be granted to anyone who invents or discovers any new and useful process, machine, article of manufacture, composition of matter, or any new and useful improvement thereof. New synthetic structures of DNA are included. So again, we're talking about the utility patent, a utility monopoly. How it's used is important. And you have to identify that use when you file the application. So again, these protect novel, useful, non-obvious creations. A public disclosure of that will give you less rights ultimately than if you had protected it first. However, in the United States, you are allowed a year grace period roughly to file your patent application. Please note that you should not count on this, this grace period, and this grace period does not apply in any other place. Any non-confidential communication gets you into this public disclosure area. It does not have to be to somebody who is completely unknown to you. It could be to your friend, and they could find that to be a public disclosure. So anything that's non-confidential. So to protect against this, ask the professional at your institution who's responsible for non-disclosure agreements or material transfer agreements, and ask for their help and advice if you plan on disclosing any confidential information to third parties. In patent applications, again, they're reviewed for novelty and non-obviousness compared to the wide world of prior art. And I wrote that very large there. Printed publications included in the definition of prior art can destroy patentability. And enabling disclosure is not only a requirement of the patent application, but it can be something that you make unwittingly to a third party before you filed your application. So patent rights are not all business. So this is a little story, a little case study on why patent rights are interesting and why prior art is important. So there was a ship, the Al Kuwait, a freighter, that in 1964 capsized outside of Kuwait's harbor. The ship was carrying 5,000 sheep. And it was recognized that the sheep began to decompose in the harbor and that ultimately it would pose a problem to the water supply for the town. Therefore, the ship was to be raised and the sheep carcasses removed from the harbor. And when they went about trying to do this very quickly, they realized that getting cranes there would take too long. Potentially, the ship would break apart. They needed to devise a quick and easy method to get the ship up faster. So the Danish inventor Karl Kreuer came up with a method of filling the ship with buoyant bodies and allowing all of those buoyant bodies to raise the ship from basically the inside out. And the sheep carcasses were to come up with it. Ultimately, his invention worked. They filled the ship with 27 million plastic balls, and they raised it at a cost of $345,000. Which saved the insurance company most of the insured value of the ship. Now, they applied for a patent, and actually the patent was applied for in Karl's name, although he later claimed that BASF had applied for the patent. This is a figure from the patent drawing that shows the method by which they raised the boat. They put all of these polystyrene balls, styrofoam, down a tube, forcing them into the boat hull until the boat was buoyant enough that it raised. Now, this patent never issued, and there is somewhat of a question as to whether it was because of this Donald Duck cartoon from 1949. Now, this is from The Sunken Yacht, a Donald Duck cartoon owned by Walt Disney Corporation. And it shows Donald Duck and his sons stuffing ping pong balls down a tube and into a ship hull to get a treasure chest out of this sunken ship. And this patent was, for the Danish inventor, was denied. And it's assumed it was because of this. However, the documents that regard the application have long been destroyed, and the inventor and the original examiner have long been dead. But this is an interesting and curious case of patenting in prior art that includes someone as jovial as Donald Duck. So patent rights can be protected in other places but the United States. And the World Intellectual Property Organization is a clearinghouse for these worldwide applications. By filing a PCT application, which stands for Patent Cooperative Treaty, you can describe your subject matter to the World Intellectual Property Organization in that PCT application, and then apply that application to one of over 150 contracting states. So what you do is you have your application translated, you have your PCT application reviewed by the World Intellectual Property Organization to a certain point. At that point, the WIPO says, okay, now you need to decide what places you want protection in. And you go forward by translating and transforming your application to meet the requirements of that country's filing office. So the World Intellectual Property Organization does not issue the final patent. Still, the office in each country does. But they allow a sort of proto-patent application that gets you through a few of the steps more quickly. And you can see on this map that many of the heavy-hitting markets in the world are a part of the Patent Cooperative Treaty, are so-called signatory states. However, there are a few key markets that are still missing. So we talked a little bit about this, but patent rights require three basic elements to make a claim or to make a patent application. You have to have utility, novelty, and non-obviousness. So what we talk about with utility is usefulness, novelty is newness, and non-obviousness is what we talked about in comparison to all prior art. It has to be non-obvious to somebody who's reasonably skilled in that the area of that subject invention. So what is patent eligible is defined in the US Code. What is patent eligible is defined as a process, a machine, an article of manufacture, or a composition of matter. What is not patentable includes discoveries, natural laws, scientific principles, natural phenomena, and mathematics. Abstract ideas, ideas in general, that's the reduction to practice step in action. Atomic weapons are not patentable. And now why is this? We talked about a patent application being a fully enabling disclosure. You're telling the world how to do your invention, how to make the thing that you're making, claiming it's yours. For that reason, we don't want atomic weapons to be described in a patent application because then anybody could find out how to build atomic weapons. Therefore, the federal law excludes them explicitly from even being eligible for patent protection. You cannot patent anything that's naturally occurring except plants. You can't patent anything that encompasses a human being, and that's for the reason that we don't want designer babies in the United States. And you cannot patent anything that has been publicly disclosed, as we discussed in some length. Again, you cannot patent anything that has been publicly disclosed. So the requirement for utility is that the claimed invention must have some application for beneficial use. The famed Justice Story, was quoted as saying, "The invention should not be frivolous or injurious to the well-being, good policy, or sound morals of society." And that's been read as part of the utility requirement. So I find the utility requirement to be the lowest bar of the three-prong requirement for patent eligibility. What you're looking at here is a picture of a product that is a bird diaper. And the bird diaper is exactly what it sounds like. It allows bird owners more freedom. And for that reason, it does have a certain utility. And you can see that it's a design that's fairly banal in their figure, so that they've applied several different designs, and either to contrast or to complement the bird. Again, a low bar. So the second prong of this requirement is novelty. Now, the invention must be demonstrably different from what's publicly available. Again, the Patent Office will be examining prior art references. And they'll be attempting to conglomerate prior art references to describe your invention fully. When one prior art reference describes your invention fully, it means that your invention was anticipated. And so, again, that means that one inventor already anticipated your invention and filed protection on it a long time ago. Or maybe even not a long time ago, but it could still be an anticipation of your invention. If it's described in prior art. So that differs from simply lacking novelty, and that lacking novelty could be any combination of prior art references. So this is pretty powerful for patent examiners because they can look through a history of everything in the literature in a certain area, and the patent offices hire people who are skilled in these areas. It's not one person that's reading these applications. It's lots of specialists who have deep knowledge. And they're looking for all of these references to combine to defeat the novelty of your claimed invention. And now non-obviousness is a bit of a slippery one for most inventors because it encompasses a lot. The invention cannot be obvious to a person having ordinary skill in the art. And one of my favorite tests to use, although it's not the only test, is the teaching suggestion motivation test. Was it taught by prior art? Was it suggested by prior art? Or was it motivated by prior art? Or any combination of prior arts together? If you answer yes to any of these, the patent could be denied by the examiner. So again, this is a broader definition than what we see here in the picture. We think Pizza Hut, we know they have pizza. So the sign seems obvious, but the US Patent and Trademark Office has a much broader definition. So as an example, we could say, okay, we have the bird diaper patent registered. We're making lots of money on the bird diaper, and we want to make an improvement thereof and register a new patent on it. So taking advice from others, we make the bird diaper washable. And we file for a patent on that to describe that new improvement. Now, somebody who used the bird diaper for a day would realize that a washable one would be better. And so the patent office would likely deny that as lacking novelty or being obvious for the same reasons. So looking at more descriptive examples for biomedical technologies, patent eligibility could include proteins and nucleic acids, tools for the manipulation or use of DNA or proteins in the lab or in medicine. It could be diagnostic kits, pharmaceuticals, microarrays. It could be software for bioinformatics analysis, or it could be industrial scale processes for the production of food or medicine. It could also be recipes and compounds. What it can't be, again, is any discoveries, natural laws, any abstract ideas, and anything that's been publicly disclosed. So we've moved from trade secrets, copyrights, to trademarks and contracts, and spent a good time on patent rights. And now we'll touch on a bit of a case study. Many of you will likely know the faces on this slide. This is, of course, the case of the CRISPR-Cas9 system. In 2012, University of California biochemist Jennifer Doudna and colleagues made a seminal discovery about how to use CRISPR-Cas9 for gene editing, and they performed their experiments on DNA in a test tube. In 2013, a group led by molecular biologist Frank Zhang at the Broad Institute in Boston also edited genes using CRISPR. And this team was able to edit the DNA inside of actual mouse and human cells and somatic cells. Now, they filed for patent, the Broad Institute filed for patent application, and so did the University of California. And in doing so, the University of California claimed that the Broad Institute patents interfered with the patent for which University of California had applied. So that lawsuit is called an interference proceeding. They said, hey, we actually had this invented first, and the Broad Institute's application was processed faster for a couple of reasons, but our application is still valid, and we want you to assess it as being interfered with by this new application by the Broad Institute. So that started a long legal battle over this potentially extremely lucrative technology. And this is an interesting case study because it's possible that there were independent derivations of this invention happening in different places. And that's always possible. And for that reason, the United States Patent and Trademark Office grants you this monopoly and puts on others what's called strict liability. If they practice your invention as you've described it in your issued patent application, even if they've derived that practice through independent means, you can still sue them as being an infringing party. So this has been an important facet in this long-running case, which has now been somewhat undercut by the fact that we now have CRISPR-Cas12, we have Cas-X, Cas-Y, and so on, other enzymes that are still useful and still effective in editing genes. So just to touch on this, what makes something patent-worthy? So this, for some viewers will recognize this image, and its rights are reserved by NBC. So we're looking at, in the University Tech Transfer Office, this core area of the sort of research to license continuum, or research to commercialization continuum. We will be assessing the patent and market, the patentability and marketability of an invention. We'll be protecting intellectual property by registering it in some of the ways that I've described, market it, find a license, and execute on a license. So we're looking first at patentability. To what extent has the invention already been disclosed? To what degree is it novel? Run it through the TSM test for obviousness. Then look at the anticipated scope of the claims. How useful is it? How many things could it be applied to? So we rate this as broad or narrow patentability using these factors and more. We look at marketability, the nature of technology in the market. Is it breakthrough? Is it incremental? We look at competitive products. We assess the market size. And we look at the value proposition and what it gives in terms of money back to the customer or value back to the customer. And we look at this as high or low. And then we look at maturity, the level of reduction to practice, the anticipated time to license, therefore, and the anticipated time till there's an actual marketable product or service. In other words, when will we start to recoup on the investments that we've made in this invention? And so we look at early or late maturity. And what we're looking for, really, is high marketability. If there's narrow or broad patentability, or at any stage, really, in the maturity, we can act on things that are highly marketable. So if you see something in your lab that looks like it could be marketable, go talk to your tech transfer officer. I've reserved time for questions, and while I'm unsure how many viewers we have online, I can at least take a question from the audience here.
Yeah, I'd like to ask, well, not ask, but could you describe the difference between a plant variety protection certificate and a plant patent?
That's a great question. The question was, please describe the difference between a plant variety protection certificate and a plant patent. Now, plant variety protection certificates are issued by a different agency, number one. They are to protect sexually propagated plants. So plants that are bred traditionally through traditional plant breeding methods produce sexually reproduced plants. So these are potentially new varieties every single time a new cross is made between two existing varieties. We think about this when we are going grocery shopping for apples. People are very familiar with the different apple varieties and the possibilities that come from crossing those varieties together. The same thing happens in plant breeding of other plants, even commodity plants like wheat and potatoes. This breeding occurs over a long time, and the plant breeder expertly down selects to make sure that they get just the characteristics from the crosses that they want to obtain. For this reason, because the process is so different, and because this traditional plant breeding has been around for so long, there's a different form of protection that allows plant breeders to preserve the rights in the work that they do to create new plant varieties that are stable when sexually reproduced.
Thank you.
Do we have any other questions? Barring any further questions, I'll end this session by saying thank you for watching. And for more information, go to ascendhub.org. We'll have more videos, more training materials, and more activities to come. So thank you.